Welcome to Employee Benefit Plans and Business Sense.
Hey everybody, welcome to an all-new episode of Employee Benefit Plans and Business Sense with Dahl and Kathleen of KLB Benefits Law Group. I'm your host, Mike Leon. Dahl and Kathleen have helped employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans, and they bring decades of combined experience in employee benefits. They bring practical real-world insight to help businesses avoid those costly mistakes and resolve plan problems efficiently. And in today's episode, Kathleen's going to walk us through how bringing in an employee benefits attorney to your correction team can actually save money for your business. So ladies, good to see you both. Kathleen, I'll start with you. Can you tell us each a little bit about your background? What made you want to get into employee benefits law?
Thanks for having us, Mike. Abdal and I met many years ago at Stanford Law School and fast friends. And then I immediately started practicing employee benefits law right out of law school. And what really attracted me to it is I really enjoy I'd worked in the business world for many years before law school, so I was very in tune and felt very compelled to have my law practice have something to do with the business aspect, the office atmosphere. And it was all about helping employers attract quality employees and helping them to offer benefits, very rich benefits to their employees. Which helps employees. Because I really felt that what this practice does is it helps sort of both sides of the business equation, both the owners and employers and the employees.
And Dahl, same question to you.
Yeah, thanks, Mike. Thanks for having us. I was originally practicing in the area of general litigation, civil litigation, and business transactions as a lawyer, and I became acquainted with what it was like to be a benefits attorney through talking with Kathleen. We would touch base after law school about our various jobs and what was her practice like, what was my practice like. And I enjoyed business transactions, and I really enjoy working with small companies, with small employers, and growing companies, et cetera. And when I decided to reenter the workforce after a short hiatus, to reenter law after taking a break, I asked Kathleen, what do you like about employee benefits? And she or what is it like to practice in employee benefits law? And she told me, and I realized that this was probably a good fit for me because I really enjoy the compliance aspect of it. I like the idea of helping a company work proactively to consciously organize their benefits, their situation in a way that will maximize the benefit to the company and to its employees and avoid expensive compliance problems and legal issues down the road. I love the idea of using law as a proactive tool, and I was not a fan of litigation. I think it's great to avoid litigation at all costs, if possible. So compliance is definitely the name of the game. And I'm a tax nerd. I love the tax code, and I've really enjoyed working in ERISA for that reason.
Let me piggyback on that. And Kathleen, let me ask you, before we even get into the specificities of all of this within the complexities of employee benefits law, why don't you explain at a 30,000-foot overview, why is it so important for employers and plan sponsors?
Well, basically, a lack of compliance, it can be very, very expensive between IRS, sanctions or DOL sanctions, loss of tax deferred, status. All of those can be very, very expensive. And quite frankly, the law the amount of law and regulations that apply to employee benefits plans is extremely complicated, and that's why you have specialists who focus purely on employee benefits because it's very complicated. It's very difficult for the average employer to actually, be able to get their arms around all of the things that they have to as, being the employer is the plan sponsor. And so, basically they have to be responsible ultimately for the compliance of their plan. And there's just no way that they can do that on their own. Even with additional service providers, the legal aspect is vital.
So let me ask you, because I've heard this terminology of a plan correction. Can you kind of explain what that is for any listeners who maybe haven't been through it?
Sure. I mean, basically, a plan correction is pretty much what it sounds like. There has been some mistake, which the IRS likes to call a failure, that needs to be fixed. And so, and they can be everything from a very small mistake that can be easily fixed to very complicated or long-term, mistakes that have been made that take a more complex correction. So, the whole area is pretty broad, and to be honest, because of the complexity of the law, almost every plan is going to experience a mistake at some point that needs to be corrected.
So let's dive into that. What are some of the common mistakes or even compliance issues that you've noticed that lead to this plan needing a correction?
Well, I would say the most common mistake that I see is usually related to they're usually payroll errors, and the payroll system may not bring somebody in who signed up to be in the 401k plan, and so this person has elected to participate, and maybe the error doesn't get discovered for months or a year, and so it's not going to be just an easy fix to start them participating. There's a missed deferral opportunity, and missed deferral opportunities in general is a very common mistake that we see. It might be because, as I mentioned, that they didn't get brought into the plan when they signed up. It could be there's a situation where the payroll system is not it's not actually set up properly to reflect what the plan document says. So the correction involves going back and figuring out what compensation should have been used as a basis for a deferral. And there's a difference between what the plan's actually, being operated like versus what the plan document says. So I would say issues with missed deferrals is probably the most common one that we see.
Donald, same question to you. Any other common mistakes that you maybe have seen that are beyond the ones that Kathleen mentioned there?
Yeah, the one super fundamental one is employers not keeping a copy of their plan document in their own records. They tend to, in my view, I've been observing that employers often think of the plan as the property of the plan provider who has sold them the plan document, and they don't take ownership of it as their responsibility. So they don't keep copies of it. They sort of think of the service provider as in-house, as part of the team and they rely on the service provider for everything, including knowing what the plan provides, implementing it. And that just doesn't work. The employer is where the responsibility resides, and they have to implement the correct payroll, as Kathleen was describing, the correct description of compensation to be used, as Kathleen described. All of those other failures can flow from just this assumption that the employer's assumption that the plan isn't really their problem or their responsibility, and in fact, it is.
And I'd like to just jump in on that. Basically, the issue of plan documents comes up a lot when we look at plans. We have a client and we ask them to see all their plan documents from the beginning of the plan, and they don't keep copies of them. And the problem with that is that, if the IRS were to come in and ask the same question, show us all your plan documents, and the employer can't produce them or can't produce signed documents. That's another big issue, is having blank documents that haven't been signed. Then the IRS is going to say, well, then if you can't prove that you ever adopted this document, then we're going to treat it as though you never adopted it. And there are a lot of plan qualification issues that rise from that. So that's one reason that we are always very concerned about employers having copies of the historical plan documents, not just the current ones, and making sure that they have signed copies. So.
Yeah, no, and I'm glad you jumped in on that because you fed into my follow-up perfectly. So let me ask you then, can you tell us about a correction case, Kathleen, this is for you. Can you tell us about a correction case you worked on that really showed the value of why it's important to have an attorney involved?
Definitely. I've got sort of a typical one, and that is, it was a situation where, again, it was a missed deferral situation. And the client engaged us and was telling me that, he had done this calculation for the missed deferral and the missing matching contribution that went with it, and he deposited into the plan. And it turns out that he'd calculated 100% of the deferral that was missed. And the IRS doesn't require that because the IRS recognizes that basically that, the employee got the money in their paycheck. It just didn't go into the plan. So the IRS requires a lesser contribution just for the missed deferral opportunity, the tax benefit. And that's 50%, or in some cases, as in this case, only 25%. And so I was able to immediately, reduce his correction by 75% for the missed deferrals because, he didn't know the law. But another one that's very big is that I had a situation a couple years ago where, again, it was a missed deferral. It was a situation where employer didn't offer his plan to employees over many years. And so the TPA that he had hired to help him fix all this calculated a corrective contribution of $250,000. And so they came to me so that I could file a submission under the IRS correction program called EPCRS, a voluntary correction program. And first thing I did was I looked at the calculations that the third-party administrator had done. And similarly, I noticed that they had not done the reduced, deferral contribution for the missed deferral opportunity. They had calculated 100%. So that immediately reduced it to about $170,000. And then I went and I talked to the client to get the history. And when we went into the VCP, I was able to negotiate with them to figure out like what they, to reduce the correction period. Is instead of like 15 years of correction, I was able to get down to like 5 years. And then, based on facts and circumstances. And then I talked to the manager at the IRS and said, what is it you're really concerned about? And figured out what they were concerned about. Went back and talked to the client and got some facts. So we were able to reduce it down to 1 year of correction. And so from $250,000, the end result was around $7,000. Now, he had to spend about $7,000 for my services over a long period of time. But he basically, for, my services, $7,000, the correction of about $7,000 versus $250,000. So, definitely an employee benefits attorney can definitely make a difference in these situations.
Remember, attorneys are advocates and negotiators, and third-party administrators are expert compliance specialists, but they don't have the training or expertise or even the bandwidth to negotiate and advocate to the IRS.
Right. Well, it's like Kathleen said, he wasn't a lawyer, right? So let me ask you then, is that the best example you can give of like first time you're brought into a correction case? That's the first thing you check for because it could change how much you're going to charge and how much things turn out. Kathleen, I'll start with you. Like, is that the first thing, or what are some of the first things that you're looking for in a correction case?
Well, when we get brought into a correction situation, I would say the first thing that I'm looking at are if it's a correction that involves some kind of corrective contribution, I'm looking at the calculations and how it was calculated first off to see if there's any way of reducing that amount. then the next thing I'm doing is I'm looking at the plan documents, or maybe I shouldn't say the next thing. In conjunction, I'm looking at the plan documents to see exactly what the plan said versus what was actually done, to make sure that there isn't some other way of looking at this, that we can sort of argue it really wasn't a failure or it wasn't as bad of a failure. But I think the most important thing that I find is really talking to and listening to the employer, because that's where I get to hear the background of how it happened, why it happened, and maybe, some sort of mitigating circumstances. So it's always important to look at all the documents and the calculations, but I think listening to the client is the most vital part of it, because you really get some insight that you can use to advocate for them.
And Dal, I'm assuming you are echoing the same.
Yeah. No, I
Yeah.
agree. I think it's true that the process Kathleen described is perfect. You look at all of the facts and circumstances and try to narrow it as much as possible, and then go in and fight for that position with the IRS.
So Kathleen, you mentioned it before about the IRS. So, and let's talk a little bit too about the Department of Labor. What steps do you guys specifically take with the IRS and Department of Labor to help that client get the best possible result on a correction?
Well, I mean, first of all, it's not every correction requires an interaction with a government agency. Sometimes self-correction is possible. And so that's one of the first things I do when I go into a correction situation, is see if it's actually something that might be eligible for self-correction. Then, if it's really something that's not going to qualify for self-correction, and we end up doing a submission, say, to the IRS, and keep in mind, the employee benefits law involves a lot of different bodies of law, but there are two main bodies of law that affect all employee benefit plans. One is the IRS code, which is sort of the requirements that the IRS sets out for basically for getting that tax benefit. The employer getting the write-off, the employee getting the pre-tax or tax deferred benefit. And then there's the Department of Labor, which basically that's the ERISA side of things. And the Department of Labor is very concerned about making sure that benefits for the rank and file employees is fair. Like, you're not giving more benefits to a highly compensated employee than a rank and file non-highly compensated employee. And also that employees have enough information to make the decisions they need to make with regards to the retirement plan, or, other benefits as well. And so if we're dealing with the IRS, we go in under their correction program, which I mentioned, the VCP, Voluntary Correction Program. The first thing that I kind of make sure I do is I come in with maybe the most aggressive solution, proposed correction, but it always has to be reasonable. I've been doing this long enough, and I've talked to enough IRS reviewers that I know that if we go in asking for something that's completely unreasonable, they're going to not be happy, and then they won't be happy for the rest of the negotiation. They're going to not trust you. So for me, the most important thing is going in with the most aggressive position I can that I can reasonably support. And then to always have like a plan, at least a plan B. I always make sure my clients know like what the worst case scenario is, things like that. But it's always a matter of being both reasonable, but also being very assertive. If I don't like what the reviewer is telling me, then I ask to speak to their supervisor. And just sort of being persistent, but respectful. And it usually works out pretty well, because I find that the IRS agents in particular, who are part of this voluntary correction program, they want the plan to stay qualified. I mean, that's the ultimate goal. They're not looking to disqualify plans. So, usually you can find some safe ground in the middle.
Right.
Yeah.
So
It's a little different under audit. That's where you haven't gone in voluntarily, and the IRS comes in and finds the mistake. So But, it's definitely, I think in either situation, it's important to be reasonable, but very assertive.
So landing the plane here, ladies, because we've talked about the legal representation part of this. What's one thing, Kathleen, I'll start with you. What's one thing you wish every plan sponsor understood about the value of having legal counsel involved in these corrections?
I think, the saying penny wise, pound foolish is very it here. I think not understanding that, having employee benefits counsel involved, when you first find a mistake, whether it's the employer finds a mistake, their payroll finds a mistake, their third party administrator finds a mistake, is get legal counsel involved. It's part of a team usually. In other words, the third party administrator is doing calculations and getting data. The employer is providing sort of the context and the history, and then the lawyer can, oversee it, help guide it, review what other parties have done, and assess, apply the law and assess what the most efficient possibility for correction is. And as I mentioned earlier in my stories, it can be anything from a little bit of savings to a lot of savings. And it's always a good idea to have an employee benefits attorney on the team because the ultimate goal is compliance. And correcting a mistake the wrong way is almost as bad as not correcting it at all.
I would add that that it's key to keep in mind that what you're paying for with legal counsel is representation of your interests. An attorney, when we're hired by a company to represent it in connection with its retirement plan or its health and welfare plan, our job is to focus exclusively on that client's interests. We don't have any other skin in the game, so we're not worrying. The third-party administrator or another service provider is concerned about their exposure to liability. They're rightly protecting their own interests. They have a contract with the client, but they don't have they're not representing the client. An attorney, which part of what you're paying for is that loyalty, that dedication to you as the client.
Right. Well, ladies, thank you so much for the insights and analysis. We truly appreciate this.
Thank you, Mike.
Yeah, and thank you to everybody out there for listening to today's episode of Employee Benefit Plans and Business Sense. If you need help with a plan correction or want to make sure you just don't make a mistake that could cost you more, do me a favor, visit klblawgroup.com to connect with Dahl and Kathleen. Be sure to leave a review, share this episode with somebody you know that maybe needs to listen to it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.